Section 24. Commissions and compensation. Follow the money. Sarah, is that your commission? Emily and Carlos's transaction has recorded. But before we leave their closing disclosure, Carlos notices one more number. He points to the real estate compensation information. Sarah, is that what you made on our transaction? Sarah laughs. That's the compensation being disclosed through the transaction. What I personally receive is handled through my brokerage. That distinction matters. Agents spend a lot of time discussing purchase prices, closing costs, seller credits, and lender fees. But the moment their own compensation appears on the settlement paperwork, they need to understand the rules just as carefully. The closing disclosure follows the money. Real estate commissions may appear on the closing disclosure as part of the transaction's disclosed costs. That means the settlement professional needs accurate information about who is being compensated and the amount being paid through closing. Imagine Sarah reviews the figures and sees that her brokerage is supposed to receive $12,000, but the closing disclosure reflects $8,000. Should she say, "Close it, we'll fix it later"? No. The discrepancy should be addressed before consummation whenever possible. Maria needs the correct brokerage instructions and supporting documentation. The agent doesn't simply get paid directly. Here's where Arizona law becomes important. Sarah is a salesperson employed by her brokerage. Suppose Carlos says, "You are amazing. I'm going to give you another $2,000 directly after closing." Sounds generous. But Sarah cannot simply treat transaction-related compensation for licensed activity as a private side payment. Arizona law regulates how salespersons and associate brokers receive compensation for licensed real estate activity. Compensation is generally handled through the employing broker. Sarah should involve her broker before accepting anything connected with the licensed transaction. The safest sentence is, "Thank you, but anything involving compensation from the transaction needs to go through my brokerage." What about rebating part of the commission? Now reverse it. Sarah tells Carlos, "I'll give you $1,000 of my commission after closing." Again, don't casually promise that. There may be lawful ways for compensation arrangements or credits to be structured, but they need to comply with applicable law, lender requirements, brokerage policies, and settlement disclosure requirements. Sarah shouldn't create a private side deal and hand Carlos cash after closing. If a commission-related credit is contemplated, the broker, lender, and settlement professional should be involved as appropriate, so the arrangement is properly handled and disclosed. Then, the title company offers Sarah something. Now let's change the facts. A title representative tells Sarah, "For every buyer you send us, we'll give you a $100 gift card." Sarah thinks, "That's only $100. What's the big deal?" Potentially, RESPA. RESPA Section 8 prohibits giving or accepting certain things of value pursuant to an agreement or understanding for the referral of settlement service business involving a federally related mortgage loan. A gift card is something of value. If the payment is being offered because Sarah refers settlement service business, that can create a serious compliance issue. The dollar amount doesn't have to be enormous for the arrangement to deserve scrutiny. But everybody does marketing together. Agents sometimes respond. But lenders and title companies sponsor things all the time. Joint marketing arrangements can exist, but the details matter. Who is paying? What actual goods, facilities, or services are being provided? Is the payment reasonably related to the value received? Is the arrangement really compensation for referrals disguised as marketing? These are not questions Sarah should answer by saying, "Everybody in my office does it." RESPA compliance depends on the actual arrangement. When in doubt, involve the broker and appropriate compliance or legal professionals. What about affiliated businesses? Suppose Sarah's brokerage has an ownership relationship with a title company or another settlement service provider. Does that automatically make the relationship illegal? No. RESPA recognizes certain affiliated business arrangements when statutory and regulatory conditions are satisfied. But disclosure and consumer choice are critical. Consumers generally should not be misled into believing they must use an affiliated provider merely because their real estate brokerage recommends it. Sarah should follow her brokerage's affiliated business disclosure procedures and avoid creating pressure or misrepresentation. The dangerous phrase, "You have to use them." Imagine Sarah tells Emily, "Our brokerage works with ABC Title, so you have to use them." That statement could create multiple problems if it isn't true. Agents should distinguish between, "This is a provider our brokerage has a relationship with, and here are the required disclosures," and "You have no choice." Consumer choice matters. Accurate disclosure matters, and the agent should never misrepresent the transaction simply to generate business for an affiliated company. What about paying an unlicensed friend? Here's another scenario. Sarah's friend gives her Carlos's name. Carlos buys the house. "Thanks for the referral. I'll give you $500 from my commission." Is the friend licensed? If not, Sarah may have a serious Arizona licensing issue. ARS Section 32-2155 restricts payment of compensation for licensed real estate activity to unlicensed persons. subject to statutory exceptions. Agents should never assume that calling money a referral gift makes it legal. When compensation is connected to obtaining real estate business, involve the broker. The escrow officer calls with a strange instruction. Now imagine Maria receives an email from Sarah. Please take $1,500 from my commission and pay it directly to this third party. Maria asks, what is this payment for? Sarah says, don't worry about it, just put it through. That's exactly the type of situation where everyone should slow down. Who is receiving the money? Why? What service was performed? Is the payment permitted? Does the broker approve it? Does it need to appear on the closing disclosure? Is there a RESPA or Arizona licensing issue? Money moving through a real estate transaction should have a legitimate, documented reason. What would you do? Imagine a lender says, Sarah, we'll pay for your next client event if you promise to send your buyers to us. Would you accept? Not without serious compliance review. The arrangement appears tied to referrals of settlement service business. The correct response isn't, how much will you spend? It's, I need my broker and compliance professionals to review any arrangement involving settlement service referrals. That protects Sarah, it protects the brokerage, and most importantly, it protects consumers from having professional recommendations influenced by hidden compensation. Broker tip, follow the money. Whenever something of value enters the transaction, ask, who is paying it? Why are they paying it? Who receives it? What service supports it? Is it properly disclosed and approved? If those questions don't have clear answers, don't improvise. Get the broker involved. Chapter 5 comes together. Emily and Carlos's closing disclosure taught us much more than mortgage math. We followed the purchase price. We tracked seller credits. We examined taxes, prorations, HOA amounts, and prepaids. And now we followed real estate compensation. The common theme is simple. Money should match the transaction. When the documents say one thing and the parties' agreements say another, investigate. When compensation moves outside the normal brokerage structure, investigate. When someone offers something of value for a referral, investigate. Now we're entering the final chapter of TRID Ahead. Emily and Carlos's transaction is closed, but Sarah's responsibility to understand what happened isn't over. In Chapter 6, we'll bring the entire course together by examining TRID mistakes, consumer complaints, enforcement, penalties, record keeping, and the practical habits that protect the public and your real estate license. Online Discussion 1. Carlos offers Sarah an additional $2,000 directly because he was happy with her representation. What should Sarah do? Answer. Sarah should not privately accept transaction-related compensation for licensed real estate activity outside the employing broker structure. She should thank Carlos and immediately involve her broker before accepting any payment connected with the transaction. Arizona law regulates compensation to salespersons and associate brokers, and licensed activity compensation is generally handled through the employing broker. 2. A title representative offers Sarah a $100 gift card for every buyer she refers to the company. Why is this potentially a RESPA problem? RESPA Section 8 prohibits certain things of value provided pursuant to an agreement or understanding for referrals of settlement service business involving federally related mortgage loans. A gift card is a thing of value, and if it is being provided in exchange for referrals, the arrangement may violate federal law. Sarah should not accept the arrangement without appropriate broker and compliance review. Sarah's brokerage has an affiliated relationship with a settlement service provider. Can Sarah simply tell every buyer that they are required to use that company? Answer, no. An affiliated relationship does not automatically eliminate consumer choice. Applicable RESPA requirements can include disclosure of the relationship and other conditions. Sarah should follow the brokerage's affiliated business procedures and should never misrepresent that the consumer is required to use a provider when that is not actually the case.